Please, Your Lordship. I beg to mention item number 14, 15, and 16.
This is for cancellation of bill.
Yes, Lordship.
For item number 13, since they are seeking time, it seems, 14, 15, 16, they correlated matters from the same case.
Okay.
So I believe the prosecution will be arguing together. The petitioner.
Yes, Lordship.
So it can be taken up together.
13 also.
Sorry?
13 also.
I think same case.
It's a connected matter,
Connected
Lordship.
matter.
On payment by the respondent or objected to by petitioner. This is matter after 2 weeks.
Much obliged, Lordship. And I
13
beg
to
to mention item number 9, Your Lordship.
Lordship, in item number 9, we have received the affidavit filed by the state regarding the constitution of the managing committee. So on our side, we have taken steps to represent before the new managing committee to come out for some amicable solution. So I'll place that on record also, the letter on the
Is
next
there
date.
any possibility of a settlement?
With the new managing committee, we don't know, but we're trying our best.
Who's paying for the state? So you have filed.
They have filed, Your Lordship.
And you are appearing for?
For petitioner, respondent number 5, Your Lordship.
Who's respondent number 5?
The managing committee.
You are the
The
management.
new managing committee.
Have you filed a power?
Yes, Your Lordship.
Power, I don't know,
For the new managing committee, not yet.
because
For the old
they
managing.
cannot appear. If a new managing committee comes, they have to file the power.
That's all. Ms. Leonard Council has submitted that she is now entering appearance on behalf of the respondent 5. But it has not been impleted.
Your
Do
Lordship.
we have to implement the respondent number 5 and the new managing committee?
Managing committee is not by name.
Not by name. So
It seems the members are the same. The secretary is still
the
the
entity
same.
is the same. Couldn't know. For the new managing committee, which has superseded the earlier managing committee. However, the power could not be filed today, and as such has sought for time to file the same. In the meantime, Mr. Leonard GA has appearing for the state respondent has submitted that the approval and constitution of the new managing committee has been brought on record before this court by way of an additional affidavit on prayer made by the parties. This is matter after 2 weeks.
All right, Your Lordship.
Obliged.
May I please, Your Lordship, I beg to mention item number 11. I humbly pray to let this matter may come after 2 weeks, as the conducting counsel is in bereavement.
You have for?
I am for GHEDCU.
For respondent
For respondent
1 to 4, Lordship.
1 to 4.
Yes, sir.
Prayer is made on behalf of the respondent number 4, seeking adjournment on the ground that the learned conducting counsel is in bereavement. The prayer not being objected to by petitioner, the same is allowed. This is matter of 3 weeks.
Similar prayer for item number 10, Your Lordship.
Yeah, so same ground. Same ground.
Yes, Your Lordship.
No objection, Lordship.
I get to you.
Obliged, Your Lordship.
Please, Your Lordship, I beg to make a mention of item number 6. I'm making a prayer on behalf of learned AAG Mr. Andy Shulai. He's having some personal difficulties. I plead for some more time.
No objection, Lordship. Lordship, items 6 and 7 are connected.
6 and 7.
Said matters, madam. 6 and 7.
Prayer is made on behalf of the Learned AAG, Mr. Andy Shulai, appearing for the prayer is made by the state respondent, seeking adjournment on the ground that the Learned AAG, Mr. Andy Shulai, who is appearing in the case, is indisposed on grounds of personal difficulties. The same not being objected to by the petitioner, or the prayer is not objected to by the petitioner. The same is allowed. As prayed for, this is matter after 1 week.
Please, Your Lordship, I beg to mention item number 8, Your Lordship.
No objection, Lordship.
On prayer made by the petitioner, not objected to by respondent, matter is adjourned. This is say after 3 weeks.
From daily list, item number 1.
Oh,
May it please, Your
This
Lordship.
contempt matter received.
Lordship,
This
before
matter
my
is
learned
received.
friend starts, Lordship, you have filed this contempt against where there's a non-compliance to the order dated 7/2/2023. We filed this contempt in the month of August. The order passed by Lordship on 7/2/2023 has granted them 6 weeks' time to comply with the order. 6 weeks has already lapsed, so we filed it in August. Now we are in February. Now after the contempt was filed, Your Lordship, they have filed an affidavit. Now I'll take Your Lordship to the order dated 6/12/2023 passed by Lordship. 6/12/2023.
yes. Yes.
That so and so, Your Lordship, who submitted that affidavit on behalf of the respondent, contemptor, has been filed. On perusal of the said affidavit at paragraph 4(9), the averment made therein is reproduced below as: the respondent's authority has already taken up the matter with MHA, and the same is under process at the end. Recent MHA correspondence dated 18 September 2023 be placed on record for perusal of the High Court. Mr. So-and-so has submitted that the case of the petitioner is under process, and as such, some time is required for the respondent to complete the process. At this juncture, no conclusion could be reached as to the fate of this instant petition. Be that as it may, the respondent contemptor is hereby given time as sought for. It is made clear that the said process should be proceeded expeditiously, and a report to be filed before this court on completion of the same. Now this is the order dated 6/12/2023, where I have made a statement that is under process. Now on the next date, they have sought for time again for filing of the status report. Thereafter, Your Lordship, last week on 12th of this month, they filed an application for extension of time. Now, extension of time, in my humble understanding, Your Lordship, is asking for extension of time to implement the judgment. That means they have admitted that they will implement the judgment. However, Your Lordship, after going through the miscellaneous petition filed by them, it seems they are asking for time to file an SLP before the Supreme Court. Now, Your Lordship, this case itself is contradictory in nature. One is that they say we are asking for time for implementation, and number two, they're saying give us time to file an SLP. Your Lordship is well aware that for filing of any appeal, permission is not required from this court. Now, how can they file such kind of application at this stage now? I have some few judgments, Your Lordship, because in their affidavit, they're trying to bring some new pleadings, which in my humble submission, Your Lordship, in the contempt proceedings, that need not go into all that. I have some decisions of this Honorable Court and Supreme Court, which I'm relying, Your Lordship, whereby this Honorable Court itself, Your Lordship, I'll just place these orders. I'll just take Your Lordship to paragraph 9. I'll read, Your Lordship.
Yes.
True it is that once the respondents were contesting all along before the Red Court, thereafter before the Division Bench, and then before the Apex Court, they have never raised such an issue, means they are adamant to negate the benefits of the judgment as available to the petitioners. Maybe at a lower level, there could have been some change in pay scale, but that will not take care of the right being placed in the rank of Assistant Sub-Inspector Warrant Officer, as it is the mandate of the judgment. Learned Senior Counsel for the petitioners has rightly placed reliance on the judgment rendered by the Honorable Apex Court in the case of Bihar Finance Service House Construction Cooperative Society Limited versus Gautam Goswami and others. Citation is 2008, paragraph volume 5, SEC 339. Para 32 of the said judgment in the context of the present case is advantageous to be quoted. While exercising the said jurisdiction, this court does not intend to reopen the issues which could have been raised in the original proceedings, nor shall it embark upon the questions, including the plea of the equities, which could fall for consideration only in the original proceedings. The court is not concerned with as to whether the original order was right or wrong. The court must not take a different view or traverse beyond the same. It cannot ordinarily give an additional direction or delete a direction issued. In short, it will not do anything which would amount to exercise of its review jurisdiction. I'll read the entire till the end, Your Lordship. The contentions of the Learned Counsel for the respondent is that the respondents have acted with good faith while implementing the judgment. The judgment has been implemented in its letter and spirit in favor of red petitioners, except for 89, which included 87 petitioners herein, only on the belief that they are already in the high scale, if placed as warrant officers, may go a step ahead. The respondent in any manner cannot be allowed to negate the operation of the judgment to the advantage of the petitioners. They have fought a legal battle successfully for a long time, so cannot be deprived of a right to reap the fruit of litigation. When the judgment has attained finality, there is no scope for introducing new pleas. The attempt to introduce new plea in effect has the trapping of a move to negate the benefit of the judgment, which in turn means disobedience of the judgment, warranting framing of the rule. Confronted with the aforestated position, the Learned Counsel for the respondent submitted that he be given 4 weeks' time to have instructions. Therefore, on his request, matter adjourned for 4 weeks to enable the respondents to implement the judgment in favor of the petitioners as well. Now, Your Lordship, I'll take to the next date when the matter was taken up. In the next page, Your Lordship. This is order dated 13/11, the same proceedings, Your Lordship. I'll read, Your Lordship. In terms of the detailed order 12/10/2018, which I've just read, Your Lordship, at the request of the Learned Counsel for the respondent, 4 weeks' time was granted to have instructions. Today, Learned Counsel would submit that he has been instructed to state that the judgment will be implemented vis-a-vis the petitioners within 6 weeks. That being so, contempt proceedings do not survive for any further consideration, are accordingly closed. However, Your Lordship, some observation was made by this court. However, it is made clear that in case of any default in implementing the judgment, filing of any fresh proceedings shall be at the peril of the respondents. After this, Your Lordship, quoted by the High Court, directed by the High Court, then they implemented the judgment. Now we are faced with a similar kind of situation.
This is
Your
not the
Lordship,
similar
they have fought a legal battle. Now they have come before this court praying for extension of time, which I have no objections to that. But it should be implemented. But they cannot come and say because we are filing an SLP.
No,
My instruction till date, they have not even prepared the SLP, Your Lordship.
no, Mr. Devnath, as Mr. Nongri has submitted, you should confine yourself to the issue in hand.
Your Lordship,
Only
here,
with regard to
implementation of the judgment.
implementation or non-implementation of the
So,
judgment.
Your Lordship, here, in this case, I have filed my miscellaneous application and there is no substitution of the matters. The annexure 1 of the miscellaneous application and annexure 4 of my affidavit in opposition filed in this case, this reply suppose, these are the same papers we are given. So, Your Lordship, subsequently, the ministry has taken the decision because it will be another problem. So, tested the matters.
Where is that misapplication?
This application item number 4, Your Lordship.
Item number 4.
Page 27, Your Lordship.
You see, this is same. The prayer here is the same. You are asking for extension of time only to implement the
So,
judgment.
Your Lordship, here this is the action time, and after this, Your Lordship, page, let us say this page number 31, Your Lordship. This is dated 9 January 2024.
As Mr. Nongri has submitted, I think this kind of petition cannot be countenanced, cannot be maintained. You are making a prayer which is, foreign to contempt proceedings.
There's a limitation in contempt proceedings, Your Lordship.
Your Lordship, this is the instruction.
Whatever you do at your own instant, that is up to you. As I think this court has also observed in the previous occasion, that if you file anything before any court, higher court or otherwise, let a proper order be placed before this court. If there is a stay of these proceedings, then so be it.
Absolutely, Your Lordship.
But as long as there is nothing on the court, the matter has to proceed. This petition, I think, will be dismissed. Anyway,
Yes.
even at this point of time, if you still seek for some time for implementation of
Only,
the
Lordship, if
judgment, then
the DG may be summoned personal appearance, then only things will straighten up, Your Lordship.
I'll give you one more opportunity. After that, the DG will have to come. Usually the court will always refrain from calling any officer for personal appearance
Some observation may be made,
until it
Your
is warranted. But if you continue to use delaying tactics for that matter, then the court has to pass observations. I will not make any observation here. I'll just say that you have asked for extension of time, and I'll grant you. Yes, Mr. Nobody, you have waited for so long. You might as well
Have to wait some more.
for some more time. Mr. Adabad, CGC has once again sought for extension of time, sought for time to allow the respondent contender to implement the judgment in question. On preamble, the same not being objected to by petitioner, the respondent contender is allowed another 4 weeks time. But this will be the last.
Because if Lord make some observation, then only will take steps, or else your Lordship.
In case no, in case no positive outcome is forthcoming, as prayed for by the petitioner, the court may be compelled to call the responsible or competent authority or officer for personal appearance for this court, for personal appearance. That's an observation.
Obliged.
List this matter.
Instead of 4 weeks, Your Lordship, you give little bit more time because if process also till
They've already taken 1 year, Lordship, to process.
Ministry matters, civil Ministry of
They've already made a
Policy,
submission, it's under process.
Policy of Finance, so it will be take time, Your Lordship.
6 weeks.
Item 1 and item number 4, same order, Lordship.
And 4 is a different thing.
1 and 4 is same year.
1 of 4 is the miscase, praying for extension.
4 is
Same order. And because item 4 is on pre-made by the landed CGC, not objected to by petitioner, list this matter after 6 weeks. I can do it.
Obliged.
Item number 2.
May it please your Lordship. Lordship, in this matter, Lordship, I have got the case diary and also the latest IO report, Lordship. IO status report, latest status report from IO. Lordship, in this matter, Lordship, I have flag marked the case diary. I have flag marked the statements of the complainant and also the statement of the members, other members of the association, Petroleum Association, and also the statement of the co-accused persons, Lordship.
In this case, Lordship, already I am on interim Lordship. I'm on interim Lordship. And this case, Lordship, as on summary Lordship, before seeing a city Lordship, I just want to write back in the case Lordship. In this case, what's happened, Lordship? Call Lordship for a crime branch, come to me on Lordship and inform me that on 29/11/2023 I have to appear before the IO, Lordship. Lordship, without any default, Lordship, I appeared before the IO, Lordship, and on the same date, Lordship, what happened? IO, Lordship, he seized some documents, Lordship, from me, Lordship, and I have handed over one cell deed, Lordship, there. After that, Lordship, what happened? IO handed over me 41A of the CRPC notice, Lordship. In that very day, Lordship, I comes to know that, Lordship, one of the car was involved in this case, Lordship. I disclosed. Yes, I was the owner of that very car, Lordship. But that very car already I have sold to another person, Lordship. At the same time, I submitted the sale deed also there, Lordship. Now, Lordship, new things comes out in this case, Lordship. I have submitted the things. After that, I reached a bail petition, Lordship. But after that, Lordship, he started to unnecessary, Lordship. He seized my bank account also there, Lordship. Already he taken my statement, already there, Lordship. Again, several times, I have to come to the Nampo police station. Again, I have to come to the Shillong, Lordship. Several times he start, Lordship. Then threatening should start, Lordship. I don't know for why, Lordship. Personal things also there, Lordship. After that, Lordship, what happened? I moved the bail petition. I got an interim protection, Lordship. Now the things start, Lordship. After getting the interim protection, Lordship, I went in the Nampo police. But there is no any condition that I should have to be appear there. Only one thing is that if they needs, he call me a phone and I will appear there. Then also, Lordship, I appeared before there, Lordship. Then I did a call to the IO. He informed me, now you should have to come to the Shillong. Again on the same day, Lordship, I've come to the Shillong, Lordship. No, you are late. Again, I returned Nampho. These things going on between these days, Lordship. But he never asked me to come to the police station. Now, Lordship, what's happened? In this case, the car, Lordship, for the having the region of that very car, Lordship, my name implicated here, Lordship. And I have, Lordship, please, Lordship, on totally clearly disclosed, Lordship, I have sold that very car to one person, Lordship, and submitted the sale deed also there, Lordship. Now the same person, Lordship, get the Jimma of that very car. Now where is my role in this case, Lordship? Here is the order, Lordship. He got the Jimma. That means not he itself submitted that, yes, this is my car. He got the Jimma of that very car, Lordship. Ribbon Sayo, Lordship. On page number 14, Lordship.
Your car is which car? Is it one or I think one or two?
Lordship, this is two, Lordship. Here the number is, Lordship, AS01DL2562, Lordship. I'm saying there, Lordship. Here, Lordship, on the same day, I'm going to the back, Lordship. On 29/11, Lordship, I have submitted a sale deed there, Lordship. On page number 14, Lordship. On page number 14, there my sale deed. I have already submitted to the IO, Lordship. On page number 14, Lordship, Annexure 2A, Lordship.
Yes.
I have already submitted there, Lordship. Then after, Lordship, on the same day, he recorded, he seized my documents also relevant to that, Lordship. I have annexed a seizure list, Lordship. Seizure list, Lordship, on page number, Lordship. On page number 18, Lordship. On page number 18. There is nothing should there, Lordship, for doing the investigation in this case, Lordship. I have submitted on. He seized all the things. It's proved that on 29/11 I appeared there. He seized my documents. He seized my mobile, Lordship, and he seized the sale deed also, Lordship. All things is there, Lordship. But now the things is start, Lordship. I itself wants to appear before him, Lordship, after getting the protection, Lordship. But things should comes out. He always having a right that there is no any condition. I will ask you whenever I need, Lordship. He come to the I come to the Nampho or anywhere. But now the thing is that, Lordship, already the things is that my implication of my case is that relevant to that very car. Already that very car, it get a Jimma of the some person, Lordship, whom I sold. Now where is my role in this case, Lordship?
Yes.
Lordship, may peruse this latest status report from the IO, Lordship.
But if the vehicle is no longer in his possession, then
Yes.
why would he be implicated?
I'll read it, Lordship. In inviting reference cited above, I am to report that the brief story of the case is that on 24/11/2023, the Petroleum Dealers Association, Meghalaya, has submitted a written FIR against the stealing, theft and adulteration of petroleum products from oil tankers on National Highway 6 from Jorabat to Lat Umroi, Umia. Due to high quantity of petrol products which is stolen, the petrol pump dealers are facing huge wrongful financial loss to the extent that they are struggling to keep their business alive. At the same time, the stolen products are adulterated and stored in various locations on the National Highway 6 in drums and other containers, which are highly dangerous as the products are highly explosive and flammable in nature. Hence, they possess a serious safety concern for the surrounding areas as well. Further, it seems to be a part of organized crime syndicate. Hence a case and investigated into. On receiving of source information, the police team consisting of various ranks has raided several places in National Highway 6 after confirming the presence of illegal petroleum products, and a recovery of various products, items of diesel and petroleum along with apparatus for storage of those materials was recovered from the illegal depot. After observing all the legal formalities in presence of witnesses, the non-transportable items were handed over to Riboy police along with the accused person by the team. Petroleum products along with various apparatus in all the PO, which is an illegal depot, was seized, and out of which one of the PO, which falls at 12 Mile Narang Riboy, belongs to one of the arrested accused person, Shri Riben Sayo. During the course of investigation, it is revealed through the bank statement of accused person that both the accused person, Shri Riben Sayo, and accused Satyendra Kumar Jeswal has a financial transaction, and the purpose is best known to both the accused persons. Further, the accused person, Shri Satyendra Kumar Jeswal, was served with notice under Section 41A CRPC on 29/11/2023 with a direction to report before the IO on or before 11/12/2023, but till date, the accused person did not turn up. Also, as per the Honorable Court Order dated 28/12/2023, which states that the petitioner is allowed to go on interim bail on condition that he shall not abscond or tamper with the evidence and witnesses, and that he shall appear before the investigating officer as and when required, but he has miserably failed in appearing before the IO, which is a pure violation of the court order. Also, as per Honorable Court Order dated 30th January 2024, his interim bail was extended till the next hearing, but in spite of this, he has again failed to appear before the IO, which clearly shows his willful disobedience of the Honorable Court Order. In view of the above fact and circumstances, since the case is in its vital stage, it is highly prayed that the Honorable Court may kindly be intimated that the bail as prayed for may kindly be not made absolute. Lordship, on the way they are involved in selling the petroleum to the illegal depots, which are situated along the national highway. So the information was received, and the raid was conducted, and those petroleums were seized. All of them, they were involved in selling the illegal depot, the petroleum to the illegal depot, instead of delivering them in the location to the owner who ordered the petroleum, but they are selling it to the illegal depot. Lordship may peruse the case diary and the statement.
No, one thing is after this court's order, see, Learner Counsel for the petitioner has submitted that the IO has never, contacted him, never directed him to appear before him. Now he is saying that he has not appeared.
He did not appear.
Is there any evidence to show that he has?
Yes,
evidence that he has contacted him or directed him to appear before him?
So the direction of the bail order and the bail order direction is there to appear, the Lordship. He should have.
No.
See, as and when required. When he says as and when required, mean it is incumbent upon the IO to. You cannot just direct a person to appear before the IO on any day or every day for that matter, only when he is required.
But the notice was served.
Who will be, the best person to know that? It will be the IO. In course of investigation, if he requires the petitioner, then he should call him. Nowadays, what you do is you make a call by mobile, or you send a text message, or those are the
Lordship. The notice was served to him. The notice was served to him, but he did not appear. But after the interim order, he should have appeared. He should have appeared, Lordship. The notice was served to him.
I have annexed there, Lordship.
He says that he has
I have already submitted that on the mobile WhatsApp also submitted medical report, Lordship, on the same date, Lordship. Here,
we are not forget about what
that
happened. What
medical
happened,
certificate is different thing.
what happened earlier?
Yes, Lordship.
We forget about it. Now what we are talking is after the order passed by this court, whether you have appeared before the IO or not. Similarly, whether the IO has contacted you or not. That is what is required to be.
Yes, my submission that, Lordship, if in the record also the camera on the number police also there, Lordship, 2 or 3 times I appeared there. I have a call details, Lordship. I did a phone to the IO. I informed him, Lordship, that I am coming to the number police station. Then he called me Shillong, Lordship. I come to the Shillong, Lordship.
Then
But he submitted it, he has appeared, Lordship.
Yes.
But
Then
I
He
am
has
not
submitted he has
meeting
appeared
with the
after
IO.
After the interim order, he submitted that he has appeared.
Then
But
why-
IO here is saying that he did not appear.
If I show a one mistake of the IO Lordship, in this case Lordship, I want to disclose this thing Lordship. Here the serial list is there Lordship. Who give the permission to the IO to hand over the mobile to me without having the Jimma permission Lordship? Many things is there Lordship. Yes, one mobile is there Lordship, in serial list Lordship.
So that mobile was handed over to you.
Yes Lordship, he hand over to my person Lordship. Without proposing the Jimma petition Lordship. That mobile is in my
Yes.
Lordship. This is the mistake of the IO Lordship.
Seize
You
item
inform?
can it be handed over without any proper procedure followed?
They filed Zima petition.
Who has filed?
No, we can't file
They
Jimma
have
petition
filed.
Lordship.
All these seized items, they have been released to them on Zima.
Lordship, I am submitting against
after
myself
that
that Lordship, the serial list Lordship, without having a Jimma petition Lordship, he handed over me the mobile Lordship. This is the investigation Lordship. What having the reason Lordship? He showed me nothing allegation is there Lordship. But thing is that Lordship, I am becoming bound to appear before the court because he make me on threatening Lordship. He arrest me anytime without having any reason. He already taken my statement Lordship on 29/11 when he sees all the documents Lordship.
Lordship.
Heard. Mr. Letter counsel for the petitioner who has submitted that in compliance with this court's order dated 28/12/2023, the petitioner has accordingly approached the investigating officer. However, on several occasions, how many times have you?
2 times in the Nampo Lordship, on him Shillong.
How many after? However, after going to the Nongpo police station twice, and also once at Shillong, the IO could not be met. In the pair contra, Mr. H. Karmi, landed additional PP, has submitted that a status report received from the IO, a status report dated
20th Feb.
2024, received from the IO would show that the IO has confirmed that in spite of the order of this court dated 28/12/2023, wherein the petitioner was allowed to go on interim bail on condition that he appears before the said IO, he has failed to appear even till date. Such act could therefore be deemed to be a violation of this court's order. It is therefore prayed that the interim bail, the interim bail granted to the petitioner may not be made absolute. This court, upon on consideration of the submission made, would not go into the merits of the case, since the matter is under investigation. However, on going through the relevant section, section of law on which the alleged offence is made out, is said to have been made out, the offence, it appears, are not so serious in nature. However, the process of investigation cannot be curtailed or stalled at this point of time. The IO is allowed to continue with the investigation and to continue with the investigation and to book all those who are alleged to have been part of the racket as pointed out in the FIR. Next. However, at this point of time, though on query made by this court, it could not be confirmed whether the petitioner has indeed made an attempt to meet the IO, or that the IO had also made any attempt to inform the petitioner directing him to appear before him. At this point of time, suffice it to say that this court is of the considered opinion that a case of apprehension of arrest has been made out. Accordingly, in terms of the provision of section 438, the prayer of the petitioner is allowed. In the event of his arrest, the petitioner is to be released on bail on the following condition. ITP condition: bail bond of 1 lakh will be, you execute a bail bond of 1 lakh.
Yes, that's right.
Bail bond of 1 lakh, and the interim bail granted is hereby made absolute. Petition disposal.
Much obliged, Lordship.
Item number 3.
Me, please, Lordship. Lordship, this matter, in fact, we cannot appear anymore, Lordship, because there's respondent 2 and 3, Lordship. Respondent 2 is represented by the present Chief, Lordship, whom we have defended in the earlier litigation, Lordship, recent litigation. Lordship, now we have to Lordship, we have to advise the parties to appoint new lawyers, Lordship, for this.
Because the respondent number 2 is the Darbar.
Darbar, Lordship, and now
is led by the acting chief.
Acting Chief, whom we defended in the recent litigation.
So these are technical issues which we have to sort it out. But so now you are recusing yourself from the matter.
Lordship.
Have you informed the petitioner?
Lordship, we are yet to inform. In fact, they're here today, Lordship. We'll inform them accordingly.
We should have.
Lordship.
Mr. Letter Counsel for the petitioner has submitted that he would not be in a position to appear before the as counsel for the petitioner on the ground of conflict of interest. As such, it is prayed that some more time may be allowed for the counsel to formally disengage himself from appearing on behalf of the said petitioner, and for the petitioner to be informed of the same so as to enable him to appoint another counsel. On preemit, this matter is now posted after 2 weeks.
2 weeks.
3 weeks, my lord. Let him
3 weeks.
Deeply obliged, Lordship.
Item number 5.
Is that NEC matter?
My lord. My lord, they filed an additional affidavit, my lord, bringing on record certain documents that was filed quite some time back, my lord, saying that NEC has departmentally closed the matter, my lord. Now, I have taken instruction on this, my lord. My lord, the CBI's stand is that departmentally may be but a criminal aspect of the matter, my lord. That has to be examined by Lord's Lord.
What is why have you come before this court?
The charges were not framed, my lord, against that.
Charges not framed.
It's a very old matter, my lord.
Very old matter. That's why we should dispose it, at the earliest. Otherwise, it's a slur on everyone, on the court. Firstly,
not crossed. Not even 8-9 years old. It is 6-7 years old.
It's 2017 matter.
But next date I'll go through. It's quite bulky, my lord. The entire thing. After 2 weeks or 3 weeks, I'll definitely argue on that.
How many accused are there?
5.
5.
How many of them are dead? None.
Some are represented by Mr. K.C. Gautam.
You'll wait till they die.
My lord.
You'll wait till they die.
Yes.
CBI matters.
I don't think they're going to die, my lord.
They go on, for ages.
True.
So, even in the stage of evidence, matter takes obtained number of times for the matter to be. Now we are only at this stage of framing of charge, non-framing of charge, discharge, and all those things. I don't know why. And the respondents are public servants.
I have retired also, and I am not getting my benefit also because of this case.
Okay.
Is retirement benefit also
Retirement
not
benefit
getting?
I am not getting. They will help. If all of these cases going on, they are not doing.
Yeah, that one.
Your provision was accused.
Yes, number 3.
Albert.
And interestingly, Your Lordship, in the earlier round of litigation, when we filed the criminal revision before this Honourable Court, wherein this Honourable Court, after hearing all the parties, remanded the case back to the Special Court to consider all the documents before framing of charge, to give an opportunity of hearing before framing of charge. CBI never challenged that. They never challenged their order of this Honourable Court, and they took part in that hearing. And here now the FIR and charge sheet has been quashed, because it was the entire charge sheet is based on invalid documents which were withdrawn, which are no longer in existence, It is from their affidavit only, it is an admitted fact that the charge sheet was filed relying on those documents, which were invalid documents, which stands withdrawn. And the main documents, was the audited statement of accounts, consolidated audited statement of accounts, which was filed, that was not, it is not, the charge sheet is not based on that document.
That is for the CBI to make out a case.
Well,
But then you cannot just drag on a case forever. Now the accused or the respondents have been discharged.
Yes.
But in the meantime, some of them have been deprived of their benefits. As I was, observing in jest that, in due course, if they die and they are exonerated, what happens? That aspect has to be considered. Well,
yes, ma'am.
In spite of, I think, so that is your instruction that in spite of the documents that they have filed, you can still make out a case.
that's what they told him. Well, I'll argue, my lord, whenever we can fix a convenient date, my lord. On that day, I'll come prepared.
Next week, Monday? Next Monday,
Monday, any other than Monday.
before 4th of March, if it is there.
4th of March, so it's okay.
4th?
4th of March.
No, 4th of March, I'll not be here.
3rd March? Then you should
3rd is
be.
Saturday.
Third?
Oh.
Okay, we can come on 3rd day. Where?
6, 7.
Then
Let's let's fix it on 7th.
my lord, 7th I'll not be here.
11, 12, 13. Any day, as per your convenience. Sir.
If it is
Fix
not
it on
before 4th of March, then your lordship may fix it
14.
after
14.
the first week of April only it will go, your lordship.
What's the point?
The whole of March I'll be out of station, my lord.
Look at him, he's crying.
Some prefix items are there, matters are there already, I have to travel, my lord.
Yes. Today is
21st, my lord. Twenty 29 possible.
20. Can we have it on 29th?
I'll 29. But it's showing 29 red, I don't know why.
That is February.
This February. 29th is next Thursday.
Oh yes,
We'll have it.
29 February. Yes, okay.
29.
Dr. N. Musical and DSGI has sought for accommodation on grounds of personal difficulty. And on consent by the respondent, matters adjourned for the day, and that is adjourned for the day. As agreed to, list this matter on 29th.
Okay.
Mr. Yogin is also there. 29th is okay.
29 is okay for you?
Item number 12.